Welcome to the First Nations Housing Webinar Series. This is where we answer questions from community leaders. I'm your host, Jan Eeks, and I apologize for the technical delay. Sometimes I think it's easier to build a house than to make a laptop work right. But we got it up, we got it running. I think we can get into this. But before we do get into it, I want to mention First Nations Housing Conference, February 4, 5, 6. That's next week in Thunder Bay. It's an occasion to talk face-to-face with people who do what you do. And I'll be there for the Builders Challenge again this year, and I hope you'll be there too. For the webinar today, the presentation will be about half an hour, and we'll take the questions at the end. But you can put your question in the chat at any time. That way you don't forget what you wanted to ask. I'll monitor the questions, and we'll talk with Kevin and Adam later. So today's session, we're going to hear from a well-known contractor with over 30 years of experience. And Kevin Connor is here to share with you how to make a contract work. Kevin, are you?
I'm here, Jan. Thank you.
There, and he has the live mic. This is good. Good to see you.
Is that working? Everybody can hear me?
We got you. So tell me, what do we need to really know about this? Do we just get into the session, or do you?
Well,
who you are a little bit.
Yeah, sure. So I'm a contractor. I've been a contractor for about 30 years, working with First Nation communities. Over that 30 years, I've had the opportunity to be involved in a lot of contracts. I know sometimes we go ahead and we sign a contract, but we don't look at the particular terms. And frankly, if you have a good builder and a good owner, that contract, once you sign it, you might never see it again. But it's only when there's trouble that the contract comes out and people start reading the terms of that contract. So before you sign that thing, boy, you should have an understanding and an awareness, at least, of what's in there. All right. The other thing the contract can do is help you to have a positive outcome. I mean, you can write in some terms into that contract that will assist you in your goal of having quality housing on time, on budget, those kinds of things. So anyway, yeah, let's jump into the session. We've got 30 minutes.
Let's see if we can bring up your PowerPoint.
Yeah, let's see if we can bring up the PowerPoint.
It's like getting a delivery of supplies for a construction site.
Oh, yes.
Getting closer.
Okay. So there we are.
The little tag on the bottom that says talks about sharing. A little button there that says hide on the, in the middle of the screen. Good. All yours.
Okay. Are we there?
We're there.
Okay, super. So let's go to the first slide. Can we get the first slide up, or do I?
Yeah, just click on the screen.
Oh, my fault. I'm sorry. I thought somebody else was moving her. Oh, here we are. Contracts. So again, the session designed just to provide a brief overview, a greater awareness of, and some insight into these particular contracts that we sign on a regular basis. I know in 30 years, I've always signed a contract for building a house or houses with a First Nation client. So again, it's just necessary to have a good awareness of what it is we're signing. So now the disclaimers, of course, I'm not a lawyer, right? And I wouldn't attempt to act as my own lawyer. When you're going to sign a contract with a contractor, you want to make sure that you have a lawyer present and that the lawyer has reviewed that particular contract. Okay? Don't act as your own lawyer. Seek professional legal advice. Okay, so what is a contract? A very deliberate kind of language here. A contract is a deliberate set of promises between two or more competent parties, supported by mutual consideration to do some legal act voluntarily. Okay, so there it is. And again, you have to be aware of each of those terms here. This is a contract. So sometimes when you're looking at contracts, it can come down to a particular word as to whether or not that contract's good or no good. So it says deliberate promises, two or more competent parties supported by mutual consideration to do a legal act voluntarily. Again, all of those are required really to make a contract. So we're going to go through that fairly quickly. Formation of a contract, 6 essential elements. We're going to go through this fairly quickly because we do have 30 minutes. I'm going to do this particular discussion during the actual housing conference. So we'll be in a room there and we'll go through it, and we've got a little more time then. So I encourage you to come to that one as well. Okay, but 6 essential elements to make a contract: an offer, acceptance, consideration, legal purpose, the capacity of the people entering into the contract, and the intent to enter into a contract, right? So again, we're going to go through it fairly quickly because we have several slides we got to get through. An offer is just a promise. I promise to build this building if you'll promise to pay me for it. And that's about where it ends, right? But it should be very clear and unambiguous. Construction projects are generally fairly complicated. It's not always clear or unambiguous what it is we're getting ourselves into when we say, I'll build you a house, So there's several questions around that building of the house that we should kind of incorporate into our contract. But as far as the first principles of contract, an offer. You have to make an offer, okay? And then that offer has to be accepted. So I'm going to offer to build a house for $20. You at some point are going to say, okay, I accept your terms. You're going to build that house. I'm going to give you $20, right? Careful here when you're doing those kinds of negotiations. Sometimes you don't know when the negotiation stops and when you've actually got the terms incorporated, right? And the other thing that could happen is I could say to Jan Eeks, Jan, I'm going to build you a house. Jan says, I'm going to give you $20, but you've got to put in granite countertops, right? So what happened right there is the offer I made to Jan is now no good. Jan has made me a counter offer, and that particular offer is now available to me to accept or not. Okay, so be careful during the negotiations. At some point, you got to say, this is it, and we'll do that in our actual contract. Okay, you have to communicate that offer. You can't just accept it between you and the man sitting in the office. Say, yeah, that's good, let's go. You have to communicate that. Often you're communicating that is you sign the contract, right? In the presence of the person offering it, or the contract. So the contractor and the man get together, you sign, and in that way you've kind of communicated that you both understood it and that you're both prepared to enter into the contract, okay? Again, if the terms are different, what may appear to be acceptance may actually be a counteroffer. So be careful with that. An offer, a lapse. There are particular times when it lapses. I mean, I could say, Jan, I'm going to build you this house, but you've got 30 days to accept it. After 30 days, my offer is off the table. It's no good. Or a reasonable time. If you don't determine a time in the negotiation, say beyond 30 days, after a reasonable time expires, and that's up to the court to decide. Anytime we're doing contracts, I mean, the court is going to look at what's reasonable. What's a reasonable period of time? 30 days is probably reasonable, right? So even if we didn't say to each other 30 days, and Jan comes back at 60 days and says, okay, I accept. I say, oh, no. A reasonable time has lapsed. 30 days is reasonable to accept. Now we're at 60 days. No, the price has changed. And Jan says, well, we're going to court. And then the judge decides. The judge says 30 days, 60 days is reasonable. Might be. It'll be up to the judge. Okay. If somebody dies, of course, the offer's over. The destruction or impairment of the thing that is subject matter of the contract. Now, this happened to me one time. So I made a deal with a guy to buy a motorcycle. So I went and looked at the motorcycle, nice motorcycle. I said, I'm going to give you $10 for this motorcycle. He says, okay. So we agreed, $10. Now, the next day when I came out to pick up that motorcycle, he had taken it for his last ride around the block and dropped it and dented the tank, and he bent the handlebars, et cetera, et cetera. So he says, okay, here's your motorcycle. I said, no, thanks. No, thanks. You have impaired the subject matter. Yeah, that's not what I agree. I didn't agree on this bike with the scratches and the bent handlebars. I agreed on the bike I saw yesterday. So again, that offer is no good anymore. And a court, I don't believe, would require me to complete that contract. Okay. Sometimes there's mistakes. You might want to, mistake is a legal term that, again, your lawyer should be advising you on. Okay. Okay. Consideration. So consideration is the thing I get, or the thing you get. It's a physical thing. Like when we're agreeing to enter into a contract, that's a promise. I'm promising Jan I'm going to build the house. So that promise is the consideration. Jan offers to pay me $20. So his promise is the consideration in this case, right? But the consideration is actually the house and the money, right? That we agree that I'm going to get money and he's going to get a house. Okay. The price for the promise given. Every contract in order to be enforceable requires consideration to support it. Again, I can't make a deal with Jan. I'll give you $20, Jan. That's it. Unless Jan's giving me something in return, we don't really have a contract. There isn't consideration. All right. So in most contracts, the exchange of promises provides the necessary consideration. Okay. So next slide. The courts, so here's something else you want to be careful of. The courts don't necessarily inquire as to the sufficiency of the consideration. That is, that if I say, Jan, I'm going to build your 5,500 square foot house in Montreal, downtown Montreal, for $140. Well, I shouldn't say that, $140. For some sum that maybe is really to my detriment, the court won't necessarily. I couldn't necessarily go to the court and say, "Listen, I screwed up. I didn't ask Jan for enough money." So the sufficiency of the consideration is not the overriding consideration there. Whether or not we agreed. Now, if I agreed to build that thing for Jan, that's it. I agreed to build it, and the court will ask me to go ahead and build it, even if, again, I don't have enough consideration. I didn't give him a price that was reasonable, right? If the court is satisfied that the parties agreed on the same consideration, they will enforce the contract. Now, I say will enforce the contract. Again, anytime you get to court, you don't know what's going to happen, right? It's all up to the judge. The judge can agree with me, that you can agree with Jan. Jan will go to court and say, I didn't do it. I will go to court and say he did do it. And then it's up to the judge to decide, right? So there's no, it's not as black and white as that. There's a lot of gray area there that the courts will interpret the law, right? So every judge gets to interpret the law. Now he will inform himself by looking at some cases that went before, but basically he's there to interpret the law. Okay. Now, right here, it says in a good contract, both parties benefit. And I want you to remember that every time you're going ahead to sign a contract, because it's really, there's no sense trying to screw the other guy, get one over on him, it's just going to be trouble down the road. Make a good agreement, sign the contract, live up to your end of the contract. If you're benefiting, if we're both benefiting, then we've got a good contract. If you try and get one over on a guy, it's just going to be trouble down the road. It always is. That's when the contract comes out and everybody starts reading the particular terms of the contract, right? And again, you got a good contractor, you got a good builder, you may never see the contract again. You'll sign it, you put it on the shelf, and that's it. Everybody knows what they're supposed to do. You shouldn't have to see that contract again. But again, that's only if both parties are benefiting. A great contract, both parties benefit equally, right? Okay, so let's move on. Certain persons are incapable of binding themselves to a contract, okay? Infants, young people, mental incompetence, drunken persons, etc. Mutuality. In order for the contract to be enforced, there must be mutuality. That is, we have to have an understanding between ourselves that we have a meeting of the minds here. We both know what the contract is for, right? And it must be mutually agreed to by the parties, right? We must agree to identical things. We have to have a good understanding in that contract of what it is I'm building for Jan, right? Is there granite countertops or not, right? The contract should really say, so that we have agreed on what it is I'm providing for the particular amount of money that he's going to pay me, right? And the agreement must be actual, not apparent, right? Offering acceptance without qualifications, within a reasonable time period, and accepted in the manner specified. Some issues that affect mutuality, again, mistakes can happen. Some can invalidate a contract. Those who are caused by fraud or dishonesty, or sometimes genuine mutual mistakes. Sometimes we just didn't, Jan and I never talked about the countertop. So all of a sudden we don't know if it's going to be granite or if it's going to be something else, right? Genuine mutual mistake, okay? Revocation ends the contract. If somebody revokes it, it's revoked. But again, under particular conditions, as we talked about earlier on, right? Misrepresentation. Again, one party tries to get something over on the other party. It's not a good contract, and it's grounds for canceling the contract. And maybe one of the parties has been damaged, right? And when we say damaged, we mean has lost some money in one way or another, and they might apply to the courts to get that money back. So sometimes the withholding or non-disclosure of a fact can be misrepresentation. Sometimes when you make a statement which you believe to be true, but is in fact not true, but the other party relies on the truth and enters into the contract, that can be misrepresentation. Fraud is very deliberate kind of misrepresentation, right? That's a willful assertion of facts that are untrue, right? And used to induce the other to enter into the contract. So that is a fraud, okay? The other issue right there, a deception. A person is induced to part with some legal right without compensation, without consideration. Again, consideration has to be from both sides. Both sides have to provide consideration to the other side. So if there is consideration without compensation to the other side, that could be considered fraud. Okay. Essential elements of fraud. Yeah, we kind of looked at them just now. It must be made with the intention of having the other party acted upon. So I'm going to lie to Jan, and because I want him to sign the contract. That's certainly fraudulent. Okay, and Jan must rely upon that and sign the contract based upon the lies I told him. Right, and the other party must suffer damages. So Jan has suffered some damages. He didn't get his granite countertop. So the cost between the granite and whatever I put in there, maybe he could go to court and say, I'd like that money back. And the court would likely support that. Duress, a physical compulsion or threat of physical injury. So Jan, sign this contract or I'm going to kick you in your ass, man. And he says, okay. So that is under duress, yeah? And that contract would be voidable or void, right? Undue influence, same sort of thing. The contract would be voidable or void, right? The court could just say it's absolutely void. This contract's no good. Or the court could say, well, Jan, you want to continue anyway without the granite top? Say, Kevin, you want to continue? Jan, you want to continue? Yes? Okay. continue, or you agree to void. Okay. All right, so let's have a look at some of the elements now of a particular contract. Okay, so these slides now just to depict the contract generally, and I've underlined that, generally illustrates the elements of a construction contract. And again, this is based on my 30 years of experience in construction and signing construction contracts all this time. My experience is, of course, absolutely unique to your experience. I only know exactly what I know based on my experience, right? So, and I certainly don't know everything. So I would like to say that this is generally illustrates the elements of a construction contract, okay? And the other thing is that every contract is really unique, right? I mean, we're building at a unique time, in a unique place, under unique circumstances, and between unique parties. You might not be using the same builder every time. So you can't cookie cutter a contract, right? Every project is unique, so every construction contract needs to be unique relative to that particular project. Okay. Okay, so here's a contract, and it's an agreement between the owner and the contractor. Right now, we said earlier the element the first principle of contract. You have two or more parties, competent parties. So here we got two parties, and we're going to date this thing, and we're going to put in the First Nation there and the builder there. And then we say the owner and the contractor agree as follows, right? We have to have mutuality. We have to have agreement. So we're going to say right here before we sign that we agree as follows. Okay. And then we're going to describe the work. We are going to supply labor, tools, machinery, equipment necessary to construct something, a house, in accordance with the documents included in contract documents. Now, right there, Article A3 is contract documents. That's where we're going to list documents outside of the agreement that are included in the agreement or attached to the agreement. Okay, and we're going to build it in the First Nation, right? So fairly specific, unambiguous. I'm supplying everything: labor, tools, machinery, equipment necessary to build the house in accordance with these documents in the First Nation, right? So if there's, again, it wouldn't allow me then to come back later and say, oh, well, I didn't know I was building it in Lac Seul. If I knew that, I thought I was building in Mishkagog. I mean, if I knew that, the price would be different. Therefore, I'm not, you know what, I don't want to do it for this price. It's going to cost some more, right? So again, very specific, even on where the thing is going to go, right? If you wanted to, you could put lot numbers, et cetera, in here. Put as much information as you can. We've said that we have to be unambiguous. We got to get as much information in this thing as we can, okay? So the contractor shall perform the work required by the contract documents to construct something in the community of somewhere. Do and fulfill everything indicated by the agreement, right? So now we're in the agreement. These articles are part of the agreement. And we say, we'll commence the work by a certain day and subject to adjustment in time, we'll finish by this day. We always include that in the contract. I find, you know, in my 30 years that the particular time it takes isn't generally the issue. I know we all like to be able to say we're going to start in May and finish by Christmas. That's what we always say, but it doesn't always happen, right? So we'll go ahead and put this in the contract and expect the contractor to meet it. We do expect the contractor to meet that date. Again, if he doesn't, you know, what are the damages suffered? So, and I have a lot of contracts or projects where the First Nation came and said, "Oh, we're going to charge you oh my God, phone's ringing." So we're going to charge you $1,000 a day because you didn't finish on time. And again, you could put that in your contract, but it's not likely that a court will support it, and they haven't in the past. Courts will generally support actual damages. So if I'm going to build a house somewhere, let's say this, I'm going to build a hotel. And I tell the owner, this hotel is going to be ready December 20th. And he then books all the rooms out from the 21st till, he's open for business. And in fact, I don't finish on the 20th. I finished on January 20th. Those 30 days, 300 rooms at $150 a night. He's lost some serious money because I did not finish the contract on the date I said I would. And again, a court would support, certainly. If you could quantify your damage, right? Then they would support that. But generally, I don't like to use that when I'm with a First Nation. There isn't a huge kind of damage to the First Nation. I mean, if it's a Section 95 CMHC house, you've lost $350 a month for 6 houses. It's worth $1,800, right? It would cost more to go to court than it would be to try and collect damages. But again, it's there. It's available if you think it's something you need to use. Okay. Agreement. So Article A2, we say that this contract supersedes all the negotiations, representations, agreement, either written or oral, related to the manner of the work. So here's where we're going to sign and agree to what we're going to build, right? But if I had dinner with the chief, so I had dinner with the chief the other day, and he said, geez, it'd be nice to have granite countertops. I said, yeah, sure would. That sure would be nice. Yeah. And then we get on site and he says, you said you were going to do granite countertops. And I said, well, no, I didn't say I was going to do granite countertops. I said, that would be nice. So again, here we are signing the contract. If granite countertops are in this thing, doesn't matter how many times I talked with the chief about it over dinner. If it's not in these drawings and if it's not in the specifications, it's not in. This is it. Anything we agreed to before, if you haven't captured it now in this contract, then it doesn't exist. Okay, we're agreeing right now that this house is based on these contract documents. Okay, so there we go. Now we go to the contract documents. This is where we're going to put in those things that we have just agreed upon. Jan and I just agreed we're going to build a house. I'm going to build a house for Jan. So right here, I list the drawings. I say, okay, these drawings is what this agreement is based on. Okay. And then generally, when I do this, I will identify each page of the drawing and list it right here. Right. So I will say, here's what I'm building for you, Jan. This set of drawings done by Joe Blow Architect, page A1, dated June 1st, 2025. And then I'll list the next drawing, A2, dated whatever it happens to be, and titled whatever it happens to be titled. Make sure that the particular drawing that you're attaching to the contract, make sure it's very, very specific here. Okay. Okay, next slide. The price. Okay, here's the price. I'm going to do the project for $1,000. Taxes. The total amount payable after tax is $1,000 if I'm dealing with a First Nation, right? And these are Canadian funds. Okay. And then I'm going to talk about payment here, Article A5. I'm going to say to the owner right here, my expectation is that at the end of the month, when I give you a bill, I need to be paid in 15 days, right? So that I can maintain a cash flow that helps support completion of the project. If I run out of money every 30 days, the project's going to take forever. I might have to stop sometimes, And you know what? I've been on reserve 30 years. I know that there are contractors coming and going. Sometimes they can't even start the job. They don't have the financing to start the job, and they will ask for a deposit. Now, we don't have to talk about deposits, but I generally don't support a deposit. Generally, what I would support is, again, paying for work in place. So at the end of the month, you or your tribal council or your inspector or somebody at least goes there to the site at the end of the month and say, this much work is done. And that's how much money you pay. Okay. And again, you're going to have to put that into the contract somewhere. But right now we're talking about the agreement based on first principles. So there it is. We sign, we date, we sign. here, the First Nation might have, the First Nation, I think, requires quorum to sign these things. So you might have 4, 5, 6, however many guys from the First Nation sign. Okay. And that's it. You have a contract. Okay. All the required terms and conditions based on those first principles we talked about have now been captured in that document, right? Right? Or is it? Right? Construction is a pretty complex little piece of work, man. You know, there's a lot of things that haven't been captured there. Now, technically, legally, that's it. You have a contract, right? And I've signed contracts like that before, 5 pages long. It says, I'm going to build this house based on these drawings, and you're going to pay me that much money, and that's it. I can get away with that. Again, that's a legally enforceable agreement, right? But construction, fairly complex little piece of business. So there are times when we want to add things to that contract so that we all kind of have a better understanding of what we're going to get in. This is where I would add a page that says granite countertops. And Jan and I would agree that granite countertops are in, so that we don't get to the kitchen stage and then start talking about what kind of countertops are in, right? What happens if this house burns down? So I'm building this thing. We get to the thing shingled and somebody torches it. Then what? The contract didn't say anything about that. So, and it's a practical consideration too, isn't it? I mean, geez, I'm the builder. I can't afford to build it again. And the owner probably can't afford to pay me to build it again. So what are we going to do? Something we should probably agreed about. It's something we should probably talked about and agreed upon at the beginning of this process, right? And incorporated it into our contract, so we knew what was going to happen, right? What happens when the homeowner decides to change? Yeah, this happens way too often for my liking. But I have a contract with the band to build a house based on those drawings, but the homeowner, you know, they want to make a change. So what are we going to do? Halfway through construction, we got to change the thing, right? What happens? How do we incorporate that into the contract? Because there may be a cost. There may be a cost to the contractor. You know, the homeowner wants to add something or add a bedroom, you know, move walls around there. Saw something on HGTV the other day, this great room layout that they want, you know. So again, we're happy to work with people to get that stuff done for them. But who's going to pay? That's always the question, right? Who's going to pay? What if there's a fire? We saw this up north last year. I was up around the Poplar Hill area, North Spirit Lake, Fort Severn area. There were some fires. Now, we got lucky. We didn't have to stop construction, but some other communities did. So what happens? If I got to stop, I got to send all my guys home, or I got to pay them to wait at home. Clears. I don't know. We should talk about that before we get in here. Yeah, here's the other thing. So I'm excavating for the crawl space, and I come across a giant boulder. Giant boulder. What are we going to do with that? We're going to build around it? Are we going to take it out? Are we going to bust it up and take it out? You know, this is an unknown condition, unforeseen circumstance. And that happens sometimes. So we should have some methodology there to deal with it, right? What about a warranty? Is there a warranty? Remember, we just agreed. We up there, everybody signed, but it didn't say nothing about warranty. And there should be a warranty, right? Do you want a warranty? And if you want one, make sure you get it into your contract. Okay. So I do a lot of work. Well, at least the last couple of years, few years, I've done a lot of work with First Nations, remote winter road kind of First Nations. So equipment, I generally would go to the First Nation, and they have equipment there already. So I don't want to bring my excavator up on the winter road, because then I got to leave it there for a whole year. I can't get it out till the next winter road. So I'd like to make a deal with the band to use their equipment, and maybe their operators. But again, this is something we need to agree upon beforehand. Who's supplying the equipment and the operators? Because if let's say we didn't agree on it, I get up to a remote First Nation in the spring, right? And I say, "Where's the equipment?" The man says, "You were supposed to bring the equipment." Now what are we doing? What are we doing now? I didn't bring the equipment. I thought I was using your equipment. You thought I was bringing equipment. Now what? Right? So again, there's all these questions that really you need to incorporate into your agreement and to have a real good understanding of. Okay. Here's another one. This one comes up all the day. Who's going to connect the house to the grid? Right. I mean, I don't. Sometimes what happens is the band will pick a site for that particular house, but it's so far away from the grid that it's going to cost it's going to cost 35 grand to run a new primary and then install a transformer so I can get this house connected. And of course, I didn't know that when I provided the price. So you should again define those kinds of things in your contract. And this is just a sample of those kinds of things that we have to get into the contract, right? Okay, so now it appears there's some other stuff. We should have probably got into that agreement, right? How do we do that? So we do that by adding a page called General Conditions. Okay, so this is where we're going to list all those other things that we didn't capture in that agreement, all the other things that we agreed to beforehand that the chief wants granite countertops. This is where we're going to put it into General Conditions. It's not on the drawing at this point, but we're going to put in countertops. We're going to put it under General Conditions. Okay, so in order to add General Conditions to that agreement, we got to go back to page 2, Article A3 of that document. And there it is again, where we describe the work. We said the contractor shall start and finish, and this supersedes all things. And now right there, right at the bottom. Oh, sorry. Where did that go? Oh, sorry. I'm all over the place here. My fault. So right there, under Article A3, 3.1.3, General Conditions. Now, we have the opportunity to add some pages to the contract that further our understanding of what's being provided. Okay, and we're going to call that General Conditions. And I think we're probably getting close to the end here, are we? Okay, so I've done a bunch of General Conditions here for you. You're welcome to read through them. Again, you're not going to use this as a cookie cutter contract because there is no such thing. You're going to involve your lawyer to develop your contract for you. But here's some terms you might see in General Conditions. And again, you can agree on whatever you like between two competent parties. You can agree to something that's legal. You can put whatever you want under General Conditions. And if you can agree on it, then it's part of the contract. Okay, as long as it's legal, as long as you're agreeing.
Question for you, Kevin. Question for you: when you have a change order that you need to do, what do you do for the paperwork to keep that clean?
Well, so change order. Now, there you can Google change order form. So what you'll do is the homeowner comes through and says, "I want granite countertops." Okay. Now the contractor will fill out a page that says to the owner that we're making this change. I'm going to change the top from laminate top to granite top, and here is the cost. And if we agree on this piece where there's mutual consideration, you're going to get a granite countertop. I'm going to get some more money. If we can agree, let's sign it, and that's it. And that becomes part of the contract. And it's if you go through General Conditions here, it does discuss changes in the work and what you got to do. So what you got to do is do a change order, and before you do the work, sign that change order.
That references the original contract, ties the two together, and you got a new price just for that change order.
That's right. The change order becomes part of the contract.
Okay, I want to throw a couple of questions at you before we quit here.
Please.
What are some tips for negotiating contract terms? You're a band council. You got to negotiate this thing with the contractor. What do you have from experience of tips to help the council or whoever's doing that to negotiate that contract with the contractor?
Oh, it's an excellent question. And again, contracts can be fairly complex documents. You know what I mean? And now you get your lawyer involved, and he starts using words like acquiesce and therefore and stuff like that. So it can be fairly complicated. But while you're negotiating the contract, go through every term of that contract, at least go through every term. And if there's some terminology you don't understand, ask the question. Say, what does that mean? What does acquiesce mean? What does this term mean? Yeah, acquiesce my right to change. What does that mean? Ask the contractor. Ask your lawyer, right?
Yeah.
And again, just have a good understanding of what it is you're agreeing to, because far too often, and I'll tell you, I'm guilty of it too. I go into the meeting to sign the contract. We sign the contract. Nobody ever looked at any of these terms further down the line. Now, I've been fortunate that I've never had to go to court with a First Nation. Never. I generally, as a contractor, I understand what I got to do. The band understands what they got to do. We never see the contract again.
One of the things I've always found is important as you're trying to work with your own lawyer is tell them what you want to accomplish. Don't tell them how to write it.
Yes.
Tell them what you want to accomplish. Let him get it in the right words.
Yeah.
Or now, as you said earlier, ask him, what the hell does that mean?
Yeah. So very often too, I try, you know what, the lawyer again is going to use all of his years of experience, his education, and put in all kinds of words that we don't understand. So at least ask what that means. We're always afraid to look stupid. There are no dumb questions, right? Ask the question, man. If you don't understand it, ask him, what does that mean? And what did I just agree to do? Right?
Now, you're used to solving problems on the go. So what do you recommend to resolve a conflict without going to court? You don't want to go to court, but you've got to solve a problem.
Yeah, going to court never. Going to court generally won't solve a problem, right? Somebody's going to win, somebody's going to lose. The lawyers are going to always win, always win. So you want to avoid court as much as you can. A lot of construction contracts provide for what's it called? It'll come to me. Arbitration and mediation. So you can put into your contract a process for mediating disputes before you get to court. So what you could do is you could you could say in your contract that in the event of a dispute, we're going to go through a mediation process with a mediator, name that mediator, and use the mediation process before you get to court, right? So, okay. Yeah, CCDC 2, again, which is a copyrighted document, has a nice section about mediation.
Okay. There's an interesting question here is what insurance should a contractor have to work in a First Nation community? Yeah,
excellent question. So the contractor should have third-party liability insurance, and that is a policy that protects third parties from being damaged. So if I'm building something and my excavator bumps into somebody else's house, this is insurance that covers third parties from damages. Okay. And then the other thing you need to have is you have to have a builder's risk policy. So we said that in the questions is what happens if the thing burns down halfway through? Well, one of the parties better have a builder's risk insurance policy. Builder's risk insures the losses during construction of the particular building, right? The liability covers third parties from damages. The builder's risk provides for insuring the property under construction while it's under construction. Okay. Now, very often, most First Nations would probably have. Oh, look at this.
Oh, we'll get through it before your battery dies.
Yeah. So most First Nations would have a policy in place already. They have a blanket policy. So if you want to go further down here in my documents, you'll find insurance right there. So what I say here is that one, either the owner provides it because he's already got it, or the contractor provides it. Somebody's got to provide the insurance. So right. Strike out the one that doesn't apply.
And the red gun is saying you need a certificate of liability insurance and workman's compensation board.
So well, yeah. So we talked about
apply that to the First Nations, I would imagine.
Yeah, so that liability policy we talked about, the general
Okay,
policy we talked about would cover all of that. Now, workman's compensation is different, right? This Workers' Safety and Insurance Board um, is different. That's required. The contractor is required to pay a percentage of wages into the WSIB. So that is required by law. He has to do that. Whether it's made said in the, it's like taxes,
right.
income tax. The contractor is required by law to do it. You don't have to say anything about it in the contract. It has to be done.
Well, we're running out of time, and you're running out of battery. And you're about ready to be cut off right there. Um, but you will be at the conference, and
Yes, I'm at the conference.
so people
Yes.
can come armed and ready to go with it. Okay.
Yeah, we might be able to get a little further down into these actual general conditions during that session.
Okay, so come and they can arm themselves with their questions ahead of time. Maybe feed them to you at the beginning of your session, so you can
Yes,
include.
please do.
Okay, Kevin Connor, thank you very much. Remember that the recording of this session will be available tomorrow on the web at firstnationhousingconference.webinars. So things that Kevin just said that went by too fast, you can go take a look at them tomorrow. The next session is going to be after the conference, Tuesday, February 11th at 10 a.m. Paul Kelly from KO will be talking about community housing challenges and sharing solutions in respective communities. Don't forget, First Nations Housing Conference, February 4, 5, 6 in Thunder Bay. That's next week. There's still time to register. And as you leave, there's a link to an exit survey that there it is popped up on the screen. Just take your cell phone, grab that, that barcode, and fill out the question, excuse me, the questionnaire. That'll help us to develop this whole webinar series. If you have specific topics you want to hear about, let us know. I'm Jan Eeks. Have a great day. I'm out of voice and Kevin's out of battery. We'll see you at the conference.